We're kicking the day off with a discussion on legal protections for racing data, and are delighted to be joined by David Zeffman and Tom Lingard. David is a partner at CMS, where he heads the Global Gambling Group. He has been one of the leading lawyers in the UK media sector for over 30 years and has extensive experience providing strategic, commercial and regulatory advice to clients in the gambling, sport and television sectors. Tom is head of intellectual property at leading independent UK law firm Stevens & Bolton. He advises numerous clients in the racing and sports sector on the legal protection, enforcement and exploitation of IP. He's a qualified solicitor advocate and has also been involved in several landmark IP cases. David and Tom will talk for about 40 minutes and there'll be time for questions at the end of their presentation. I'll now hand over to David to start us off. Thanks, David.
Thank you, Caroline. Actually, when I saw this was in the cinema, I was a bit disappointed that we didn't have up in lights the legal protection of horse racing data. And actually, if there's anyone here who's as old as me, I remember when I started going to the cinema, there'd be a B movie, supporting movie to the main feature. Well, this is the B movie now. So this is actually the legal protection of horse racing data is an incredibly complex topic, and Tom and I could spend the whole day lecturing you on it, but you'll be pleased to hear we're not going to do that. We'll try and keep to the 40 minutes that Caroline mentioned and keep it reasonably high level, and then you can ask the difficult questions when we're finished. So the supply of fast and accurate data is of course critical for sports betting. So whereas in the days when you could only bet pre-match or race, this was really primarily about the fixture list and the participants, the huge development over the past few years has been the advent of in-play or live betting. And obviously this requires an enormous amount of additional data for bookmakers, both to be able to offer bets in all the different markets, but also to manage their books efficiently. And this whole topic has been given an extra impetus over the last few years with the advent of regulated sports betting in the US, albeit that there the underlying legal structure of rights protection is very different. And for what you would think would be a straightforward commercial relationship about the supply of a feed of sports content to a bookmaker, there's actually a very complex web of different legal issues which underlie it, including copyright, database rights, contract, breach of confidence, competition law, access to public domain information, sports integrity, and even, and we probably won't go there today, a bit of Brexit. So these are the sort of headline categories of racing data. I mean, pictures commentary, not really in the same class as the rest of data because it's, you know, live video and audio. Fixtures, the race meetings, runners and riders, self-explanatory, conditions, the going, the weather, updates, so non-runners, withdrawals, going changes, overweights, etc. In running, obviously, off time, finish time, weighed in, results, and then again, slightly different category, betting shows and SPs. So I'm going to hand over to Tom now, who's going to explain the legal protection that underlies all these different categories, and then I'll come back and take it a bit further and look at how you can protect those rights, or alternatively, if you're a user who doesn't want to get official data, how those people go about it, or try to.
Thank you, David. Morning, everyone. Very pleased to be here. And as David said, this is a topic about which we could talk at length. I won't. I'll try and do, if not a gallop, then at least a fast canter through the legal protections from an IP perspective that have got us to where we are from a legal point of view. And even by this quite esoteric standards of intellectual property law, databases and data are possibly the most intricate and fiddly to address. But pre 1996, it was relatively straightforward, at least in the UK, in that databases, which obviously back then were much less complex and data-driven than they are now, were understood to be protected as compilations effectively under the law of copyright. But things changed rather in 1996 when the European Union brought in the Database Directive, and that was intended to try and harmonise the law on databases and their protection across the European Union, both in terms of how they're protected by copyright and by introducing what was called the sort of sui generis database right, which was a different category of protection. And all three of those different types of protection still apply to varying degrees. So looking at them in turn, you have effectively, first off, literary copyright, and this is, most people would sort of appreciate what that is, but in practical terms, in terms of where we are now, that protects the underlying copyright work. So if you have a database which, for example, a photo library, which has a selection of copyright works within it, it's literary or artistic copyright that protects those. It still also protects tables and compilations, but as a result of the case law that I'll run through after this, it doesn't protect a database itself. So it's not as useful as it used to be, shall we say, from a database perspective. And you can infringe literary copyright, like any copyright, by reproducing a substantial part of the work in question without authorization. Then you've got database copyright. Now this is a slightly different animal from a copyright perspective. It protects the structure of a database where the selection or arrangement of the contents of the database constitute the author's own intellectual creation. It doesn't cover the data within the database itself. And again, it's infringed by the unauthorized reproduction of a substantial part of that database copyright. Because both of those two are kind of creatures of copyright, their duration is for the life of the author of the database and then 70 years onwards. And we'll come back to how those are then applied in modern scenarios. Then the sui generis right, which was the new arrival on the scene, this is designed to protect databases in which there's been a substantial investment in obtaining, verifying or presenting the contents of the database. And unlike the sort of substantial part test under copyright, it prohibits the extraction and or reutilization of a substantial part of that database. And pre-Brexit, we promise we won't talk about it much, but pre-Brexit, the maker of a sui generis database had to be within the EA. Post-Brexit, the UK legislation has been amended to refer to the UK, but effectively, at the moment, there may be some databases where you have a kind of overlapping protection. You'll have a database right that was created under EU law prior to December 2020, which would still be enforced, but from 2020 onwards, it's only the UK post-Brexit version of database right. Unlike copyright, the duration of the sui generis right is only 15 years, but if a database is changed substantially, then a new right can persist. So for a database of any size which is regularly being used and updated, it can likely be a sort of perpetual right insofar as the database is constantly being refreshed. So those are the three headline areas of protection. So we just thought it'd be helpful to quickly run through, with those in the back of our mind, how the law has developed in the last 20 years or so, because there have been a number of cases, well, been many cases of some level of complexity which have tested the edges of where all these rights sit and how they apply to different types of data. So the first case we wanted to mention is really the landmark case on the sui generis database right after it came in. I remember fairly shortly after I qualified as a solicitor, the case came out and the head of my department said, there's this new case on databases, we've been asked to write an article about it, here's the judgment, off you go, see how you get on. And it was just somewhat daunting, and it took me a while to get my head around it, and I think it was quite a surprising case at the time. But effectively, and I appreciate many of you here probably know this already, but the British Horse Racing Board was performing its role in pulling together lists of runners and riders, deciding weights, handicapping, publishing the running list. And it sought to assert the sui generis database right in that data against William Hill. And the thing that was interesting about the case was the European Court said, well, actually, the investment that you need for your sui generis database right to subsist can't be directed at creating the data. It has to be in the obtaining, verifying and presenting of it. And because you are the British Horse Racing Board, what you're doing is you're creating the lists of runners and riders, and you're effectively putting your stamp of authority on those, and the data comes into being effectively when you confirm that. Therefore, all of your investment, all the money you spend, huge amounts of money every year in pulling all this together, isn't in the right place. You're investing in creating, not verifying, obtaining or presenting. At the same time, I think on the same day, a series of cases about fixtures marketing, involving fixtures marketing, judgments were also handed down in November of that year. And these also confirm that the investment in obtaining the contents means investment in seeking out existing and independent materials and collecting them in a database. So the sort of net effect of those cases was that organisations which are creating data need to show they've also made investment in obtaining, verifying and presenting it in order for sui generis database right to apply. And the net result was effectively that there is no sui generis database right in race cards or fixture lists. So following that, so a few years later, it was the sort of football industry that took the reins in terms of progressing the case law in this area. And there are a couple of cases involving Football Data Co. The first one, which was a High Court claim, started in 2010, and effectively it had previously been pretty settled, and I think there was a Littlewoods case in 1959 that the list of fixtures was a compilation from a copyright perspective. But Football Data Co, and in light of the BHB case, brought 3 claims against Yahoo in respect to the fixture lists, one based on literary copyright, one on sui generis right, and one on database copyright. So all 3 of the columns in our first slide there. The claims on literary copyright and sui generis right failed, sort of perhaps quite understandably based on what had gone before. But there was evidence that in terms of the database copyright, the creation of that database did involve a significant amount of knowledge. The people who are creating the fixture lists gave evidence to suggest that it was their knowledge. They were thinking about who could be paired with who, which teams should play when, and that if 2 different people had been asked to put together that fixture list, they would have come up with different things. Therefore, there was the amount of intellectual effort required to meet the threshold for database copyright should be met. That question was then referred to the ECJ, who subsequently gave a decision in 2012. There were lots of smaller cases and cross appeals and things going on here, but I won't trouble you with those. But the net result of that case was that the ECJ focused on the kind of golden rules that apply to fixture lists. Things like teams can't have consecutive home matches. Certain teams can't play at home on the same day if they're in the same city. You need to have an equal number of home and away at different points of the season. And the ECJ's view was that because of these rules, there wasn't actually creative effort going into creating these fixture lists. It was all dictated, or at least dictated by the rules to a sufficient extent to mean that there was no literary or database copyright in fixture lists, and as we found out already, there's no sui generis database right. So, following all of those cases, fixture lists and race cards, effectively, there's no literary copyright or database copyright or sui generis right. But what about live data, which, as David's mentioned, is much more interesting and important these days in many ways. So this case, Sport Radar, Football Data Co and Sport Radar, was again a Court of Appeal case, and again it had a somewhat complicated procedure through the courts. But effectively, Football Data Co produced live match data, including things like the score, the time of the goal, who scored it, cards, corners, free kicks, etc. There was some data which was potentially more subjective. So, for example, there was data which might be corrected later. So, the analyst might say, okay, well, it was that person that scored the goal. It turned out not to be the case. That was offside. It wouldn't be the case. With VAR, it would have been a whole different thing. But that was the match data in issue. And essentially the court found that database right did persist because the data that was being gathered by the analysts watching the games was objective and was being collected by observation. The collector didn't have control over much of the data. If a goal had been scored, it had or it hadn't. They were observing and recording that. And the fact that there were some subjective elements, so who the player of the match was, didn't mean that the database as a whole lost protection purely because of the presence of those things. And then on infringement, it was decided that the users of that data were extracting a substantial part of the database even when only goals and times were used. So because there was a change at one point during the proceedings in terms of the data that defendants were offering. But effectively, that following appeal, even just the score, the time of the goal and the scorer, which was sort of the most objective data, even that constituted a substantial part of the database. Now, there was a subsidiary issue in the case, or a sort of parallel issue, which was whether someone who operates a website which contains that material is infringing when a user actually of the website makes use of that material. And it was held that they were, if a website has got that material on it and the user of the website will inevitably copy that data onto their PC or onto their phone when they're using it, then the website operator is liable as a joint tortfeasor in that scenario. So I said there are only three categories of IP right at the start. There is a fourth element, which is that of breach of confidence, and this is something which has come up more recently, and there's been one particular case involving that, which may be known to you. So, a quick recap on the breach, how breach of confidence works. The sort of traditional test for breach of confidence is effectively that the information in question has the necessary quality of confidence, that it's imparted in circumstances imposing an obligation of confidence, and that there's unauthorised use, and that's a sort of classic test which arises from a case called Coco and Clark. Many of you may remember the Catherine Zeta-Jones and Michael Douglas versus Hello, which was a case, about 8 or 9 cases actually, which involved the confidential information and access to their very private wedding, the rights in which they had sold to OK magazine. And that case considered this area in the particular concept of, in the particular area of information which has a commercial value. In that case, the fact that they were getting married and certain aspects of the wedding would eventually become matters of public domain. But it turned on the fact that photos of that event were something which had commercial value. They had put protections in place to make sure that no one who attended the wedding took photographs, so that value could be maintained for the benefit of OK magazine, who was paying £1 million to publish them. And effectively, the case which went to the House of Lords said there's an element here where you look at information which has a commercial value, and the control of that is something which can be protected under the law of confidence. Not strictly relevant for the case we're about to look at, but a more recent development is the Trade Secrets Directive, which was, again, a creature of EU law, and it was designed, like the Database Directive before it, to try and harmonise the law about trade secrets across the European Union. There was quite a wide divergence of approaches to trade secrets, and different courts in different countries took different approaches, and procedurally things were quite different. So in some countries it was impossible to bring a claim for trade secrets without publishing those secrets in court. There weren't mechanisms by which they could be kept confidential. The UK's approach was that actually our common law of trade secrets and confidential information covers all that. Our procedures are in keeping with it, but there was legislation which introduced this definition of a trade secret to the UK legislation, and it's something which generally now would be relied upon in confidential information cases, if not on its own, but in parallel with the more traditional tests. But again, I put it in here because it sort of highlights these three factors which form a trade secret. And it's something which is secret in the sense that it's not generally known or readily accessible to persons within the circles that normally deal with that information. And it has commercial value because it's secret, and it has been subject to reasonable steps to keep it secret. And those are all things which you can sort of map and apply to to live data in certain circumstances. So the case that really tested the ground on confidentiality was the Racing Partnership and SIS back in 2019, and I'm sure this is known to many people in this room, in many cases better than it is known to me, but the basic facts were that the Racing Partnership had an exclusive right to collect and distribute live data from arena racecourses, and SIS had previously had a similar agreement, but it didn't want to take a licence from TRP, so obtained a licence from the tote who had access to on-course information. And in the course of the proceedings, SIS did also acknowledge that it had used some data in breach of arrangements with Betfair and BetDAC in terms of scraping that data from those websites. There was the key issue was that there was no contractual obligation of confidence between SIS and the Racing Partnership because there was no contract there. So the Racing Partnership had to try and rely on the equitable duty of confidence, that Coco and Clark test. But in this case, the information was not in the same way Michael Douglas's wedding was locked down. It was information which was being, was happening on a racecourse in front of thousands of people, was being broadcast almost immediately afterwards on television. And so there was a real question as to, well, is this genuinely confidential information? The case went one way, it went another. There was an appeal in which various issues were decided not by majority and things were reversed. And again, I won't take you through it all. But the takeaways, as far as today's discussion is concerned, is that it was held that the compilation of data could constitute confidential information, even though it was being relatively swiftly publicised through various routes. Again, that concept of having control and access to it was important. So SIS was not liable for misuse of that information because it had, in terms of the equitable test, it had obtained a licence to data from the tote and had received a warranty from the tote that it was entitled to grant that licence. So it had no reason to believe that there was the information was protected by an obligation of confidence. However, it was found to have engaged in a conspiracy to injure TRP by unlawful means in respect of the data that it had taken from Betfair and BetDAC. So that, as I said, was a fairly swift run through the cases that got us to where we are. And so I'm going to hand back to David to talk about how that applies to these categories of data.
Thanks, Tom. So coming back to the different categories of data, obviously pictures, commentary are the most valuable, but actually in terms of what we've been discussing this morning, it's the most straightforward legally. Because video pictures aren't really data in the same way as everything else we've been talking about, and essentially they are protected by the practical need to have physical access for TV, cameras and production facilities at the racecourse. Fixtures and runners and riders, as you've heard from Tom, sort of pre-race data aren't really protected as a result of the William Hill BHB case. But the next few, the conditions, updates, in running, off time, finish time, weighed in, and results are all what is generally called race day data and come within the category of live data in the Sport Radar case. Betting shows and SPs, again, slightly different, and that was mainly what the SIS TRP case was about. And actually, I'm not sure they are as relevant today because at that time, the betting shows and SPs were determined by the on-course bookmakers, and today it's all determined by the off-course bookmakers with no on-course element in the determination of the betting shows and SPs. So I think that's sort of to one side nowadays. But given the case and the decision of the Court of Appeal in the live data case. As a result of that, the rights holders, so Football Data Co in the case of football, the racecourse groups in the case of horse racing, now have had very valuable data which they license directly or indirectly to bookmakers, and from which they are earning significant revenues. And I mentioned at the beginning the distinction between official and unofficial data. So official data is essentially data which comes from the authorised source, the rights holder, as I say, Football Data Co in the football context, the racecourses in a horse racing context. And then the key commercial drivers in favour of using official data are accuracy, integrity, and perhaps most importantly, speed. The key commercial negative for the buyer or user is cost. And particularly where the rights holder licenses distribution exclusively, the user, the licensee, has got no alternative. So there is a tendency, and there has been a tendency over the past few years with data rights, like with media rights, for the price to progressively increase. And that obviously leads the users, whether that's a sort of an aggregator or another intermediary or the bookmakers themselves, to try to think about, well, are there ways in which I can get that data without going to the official source? And I think there are sort of three main areas to look at on that. The first one is off-tube collection. So in other words, you don't get a direct feed of the data from the official provider. You watch the race or the match on TV, and you compile your data by watching the race. Now, where it's a free-to-air broadcast, there's probably nothing to prevent that collection. I mean, there are a few minor arguments, but essentially I think that is the case. But obviously, particularly with free-to-air broadcasts, what you are losing is the speed, because the latency is greater. Where, however, it's a pay TV channel you're watching and there's a commercial subscription, typically the subscription terms will prohibit the use of that broadcast for commercial purposes. So this could, in theory, expose the off-tuber to a claim for breach of contract, where the broadcaster could seek an injunction. And actually, even if the bookmaker or the aggregator uses a sort of third-party agent or intermediary to collect the data off-tube, they still might be liable for procuring a breach of the broadcaster subscription terms. So that's off-tubing, which in a sense is probably the most straightforward for someone who wants to use unofficial data. The next area is scraping third-party websites. So there are two key legal issues here. The first is infringement of a third party's intellectual property rights, whether that's copyright, database rights. And the second is possible breach of the third-party website's terms and conditions. As far as infringement of intellectual property rights are concerned, the key issue for a claim to be successful in the UK courts is demonstrating that the scraped data is used on a website which targets UK consumers. But if there are no IP rights subsisting in the data which is in question, third-party websites will often seek to prevent data being scraped from their site by prohibiting that in their terms of use. The third area is sort of in-person collection of the data by typically scouts at the racecourse or at the stadium at the live event. So most sports which generate a significant amount of betting revenue have terms of admission, and these may be incorporated into the contract for the purchase of a ticket to the event, or they might be binding on a journalist who's asked to sign an agreement before they're allowed access to the event. If those terms are breached, then the attendee will be trespassing and in breach of the terms. And these terms often prohibit the collection and distribution of live data. For a non-journalist attending a stadium for the purpose of collecting data, the difficulty in taking enforcement action against the attendee, the scout, will often be demonstrating that they are bound by the terms, which requires the scout to have known about them, i.e. they saw the terms at the point of sale. But that may be more difficult to demonstrate in cases where tickets are bought over a counter rather than online, although increasingly tickets are sold online. And in practice, data collectors are on occasion ejected from the stadia immediately once they're spotted. But some companies regularly rotate data collectors as one way of getting around any bans or suspensions that stadium owners seek to put in place. But even doing that, rotating the collectors, might not protect the aggregator who's employing them from liability if it can be shown that they were aware of the contractual terms in place and still proceeded to instruct data collection. I wanted to talk about a few other legal issues, and there are loads of other legal issues, but all we've been talking about relates to the UK. Every country, I mean, okay, the EU has a degree of harmonisation through the database directive and so on, but all of these different locations, you know, where the event is taking place, where the collator collector is, where the bookmaker is, where the bookmaker's servers are, where the punters are, can lead to a different result in the legal analysis. Mentioned briefly data protection, and this is perhaps more relevant to football, although I suppose it might apply to a jockey, but for specific information about the player that might constitute personal data for the purposes of GDPR. And some of you will remember that there was this Project Red Card a few years ago where someone had got together, supposedly signed up a bunch of players and was seeking to get money from enforcing or licensing the rights. That seems to have come from nothing. But I think that was based on the player's sort of personal data. Now, the other area, and the last one I'm going to talk about, which is particularly relevant, is competition law, also known as antitrust law. As I say, it's very fact-specific, and competition cases are very time-consuming, very costly. Very broadly speaking, there are two types of competition claim. One where it relates to an agreement between two or more people which has a restrictive effect on competition, and the other is where you've got someone who has a dominant position, which is not necessarily a monopoly, but they've got significant market share and are found to have abused that. So actually at the time of the BHB case, we were acting at the races, and they'd been in negotiations with the BHB about the supply of data. And this was just when At the Races was launching. When, and the BHB was seeking to charge millions of pounds for the licence. When the ECJ case came out, ATR said, well, why are you still trying to charge the same amount? because you don't have any intellectual property rights. And the BHB was saying, no, you still need this live feed from us, and still costs us the same to produce it. So ATR brought a case saying that the BHB were abusing their dominant position by excessive pricing, which is a notoriously difficult claim to achieve. And in fact, we were successful in the High Court, which was a groundbreaking decision at the time. BHB appealed, they won the appeal, and then it was settled. And actually, just on the CIS TRP case, where we were acting for CIS, we had leave to appeal to the Supreme Court, and the Supreme Court hearing was about to start in, 2 or 3 days' time, when again there was a settlement. So the other competition case I'll sort of touch on briefly is on the football side. 2019, Football Data Co. appointed Genius as its official exclusive betting data partner. Sport Radar, main competitor of Genius, brought a challenge saying that the arrangements between Dataco and Genius in a breach of competition law, challenged the exclusive 5-year license, bringing a competition claim in the Competition Appeal Tribunal, and also filed a claim in the High Court against Sport Radar. Sorry, and this was a counterclaim by Football Data Co. and Genius in the High Court, claiming that Sport Radar scouts have breached the terms and conditions of the tickets, and were therefore trespassing. The data collected was confidential information or a trade secret, and Sport Radar's activities therefore amounted to breach of confidence, and Sport Radar's and Scouts' activities amounted to an unlawful means conspiracy. So that case, and particularly the counterclaim, would have perhaps resolved those open issues from the CIS TRP case, but again, it was settled, so we still don't know. And then you'll have seen 2 or 3 months ago, Football Data Co. have renewed their exclusive agreement with Genius. Whether more competition claims will follow, who knows? I think probably we've done enough for now, and questions, please.
Yeah, just one question about, you mentioned the sort of methods of illicit data collection off tube or breach of contract entering the ground. What about things like drone activity where they sort of fly between the two?
Yeah, look, I don't know the result of this, but certainly there was a time when people were using drones to fly over racecourses to try and get advantage in running races on Betfair or whatever. And I think Arena did bring a claim against someone. And as far as I'm aware, that's not happening anymore. I don't know the legal basis for it, but I don't think it's happening anymore.
Hi, good morning. This is Kanichi from Japan Racing Association. I've got a unique question maybe to you from an international aspect, which we are facing currently, which is a bit uncomfortable situation for us. So it may be referring to an official data or unofficial data, but so when we go to like bookmaker's website, we see our racing result being used for the betting purpose. And I couldn't find any evidence that we had any agreement between the bookmakers for us to share those information, although it's maybe not official because everyone can know the result of the racing. But I was just wondering if this is something we can do to make it in a proper way for a future.
There's a number of aspects to that. There is, is there a database protectable in the results, that you create or that's created in Japan, and if so, is that recognised in the UK or not? And we saw earlier about how with Brexit, that for the COI generis right, you needed to be in the EU. And then, at what level is and where is that data coming from? Copyright recognises that the sort of international recognition of copyright and database copyright is probably better than the sui generis one. But it would be a question of, and I have had given sort of similar advice to organisations in other territories where you look at whether the creator or maker of the database that may be being used is a qualifying person effectively, or where does that give rise to rights, and then are those rights being infringed, and where is that infringement happening? But I don't know if Dan, you think.
I think it's a great example to show the complexity of the area here. So what are the inherent latent rights of, yes, there's some potential intellectual property rights, but you've got the international element which may undermine those. If it was a very live feed, so they're getting the information directly from the racecourse, then some of these TRP and CIS rights may come in. If there was some reason to think that the information had been scraped from another website, then there may be some potential claims in that. But you see, what is a very simple question has an extremely complicated answer, and I think that's inherent in the nature of these kinds of rights.
There's also a point about, I mentioned earlier about how there's a difference between creating the data and obtaining, verifying and presenting it. And to the extent that a party in one country is creating data and a party within the UK is going out and obtaining and verifying that, or it's mixing it with data that it's also verifying to create a new database, that database might have protection and that might be the one that's being infringed. So you have to look at, where is this stuff, sort of springing into life, how's it being combined, and then where is the extraction taking place?
Thank you. I understood it's a complex situation. So maybe one last question. So do the bookmakers have to ask officially to a racing authority if they wanted to use a racing result? Or they can just pull out from anywhere if it's a general information?
Well, again, not an entirely straightforward question. The reason we talk about rights is that effectively to be able to take action against someone, you need a right to be able to enforce against them. So that's basically the answer. If there is no underlying intellectual property right or other right in the information, then essentially a third party is free to use that. So, whether a bookmaker requires the agreement of the event holder or the collator or whatever to use the information is basically the flip side of, are there any rights in it, which is a very complicated question, and we've just heard that. The only possible extension of this, and I'm going to put this back to David, is, of course, bookmakers are regulated in this country by the Gambling Commission. There's a detailed code called the LCCP. And the only question is there an additional element on bookmakers when they are using data which engages regulatory issues? And so you put me in it, David, I can put you in it.
I think the answer is no, actually. But I was just reading this morning, so Andrew Rhodes, who's the Chief Executive of the Gambling Commission, is at G2E, the big gambling conference in Vegas. And he was raising an issue in a speech yesterday about, micro betting and the issue where, I don't know, it's the time of the goal that was scored, someone's had a bet on, or who actually scored it. And that's led to a number of disputes between punters and bookmakers, because actually there can be different sources, one saying the goal was scored, after 29 minutes and 50 seconds, somebody's saying no, it was after 30 minutes and 5 seconds. So he's raised that as an issue, but do I think this is something which is going to result in a breach of bookmakers' license from the Gambling Commission? No, not really.
Yeah, I think it's probably most likely to be an integrity issue in terms of how accurate is your data. And that's where the Commission's concern is not, are you in some way filtering the rights of the events organisers? That's just a question of law, I think. But, the two are not completely independent. If you're using unofficial data in one way or another, there may come a point where it's unreliable. And if you wanted a strategy to put in place to prevent or deter people using that, that may be one of the things you think about is a regulatory approach as much as a legal one.
Thank you. Very helpful and very interesting. Thank you so much.
You mentioned scraping websites and doing stuff off tube. You didn't mention sort of rekeying data. It used to be quite a big thing where people were just seeing information, on another website, rekeying it, potentially reselling it or using it themselves. Where do we currently sit with rekeying data?
I think from an IP perspective, it's not necessarily the method of extraction, it's how much you're extracting, and if you're extracting a substantial part. So it's obviously a little more effort, and so therefore, slower. But if you employ someone to effectively rekey an entire database, then you've taken a substantial part of that database. And from a copyright perspective, at least, substantiality is looked at both quantitatively and qualitatively. So if there are 10 really valuable bits of data that is really what you're paying for, and you rekey those, then that's a substantial part, as opposed to rekeying 1,000 entries that no one really is interested in. But yeah, I think that would be my.
Yeah, I think it doesn't work. Is the answer.
Yeah, it doesn't get you off the hook. I mean, the whole area of data scraping is another lecture, which we're particularly in the area of AI, because data scraping, data mining exemptions, the extent to which terms and conditions that prevent it are enforceable if they're trying to stop you doing something you're allowed to do as a matter of law anyway. It's another layer of complexity there, but yeah, in terms of the method, that doesn't really impact it.
Question for the lawyers. Given how impossibly difficult the law is in protecting data, is your view that the only way you really can is from some form of sports data right? Like, for example, in some states, in the States, in France, in Australia, there are certain regulations. Do you think that's going to ultimately be the only effective way sports rights holders can protect its data?
And I think it would work if it happened, but it's been talked about actually in a racing context for years, the idea of replicating the French organisers' right. But I don't really see it happening, to be honest, because it would require legislation. I just don't think it's going to happen. But I mean, if it did, yes, that would be much better than, do us out of a lot of business. But I mean, it would be much more secure.
There's a lot of rights holders and suppliers in the room who have actively tried to speak to companies who have been in breach or using unofficial data individually. Is there more strength in rights holders and suppliers and distributors working together to go after companies that are breaching or using unofficial data? Or is there a way you'd suggest, both in the UK but also internationally, that rights holders together with distributors and the companies creating the data can work together to better protect the data?
Look, I'd say in principle, yes. But you also then have to worry about competition law again with people acting collectively. I mean, look, if they're acting collectively to enforce their rights, again, in principle, that ought to be fine. But as soon as organisations which together represent most or the whole of the market start working together, you start having to worry about competition law. Right.
Yeah, I mean, yeah, exactly. That's always the alarm bells go off when you talk about that. I suppose the one area where some of these cases become complex is because of the lack of standardisation or the patchwork nature of things, and the fact that there are so many streams and things going from different places. And one of the things you're doing, your primary job really as a claimant right holder, is to say, hello court, these are my rights in words of one syllable that you can understand. This is how they flow through to me as the right with the person to enforce that. And not just in this area, but in lots of IP cases, actually proving that is quite evidently difficult because the agreements aren't quite right or they don't quite match. So you're sort of handicapping yourself slightly in terms of proving the rights you've got. So there are ways in which I think, commercial entities can work together to make sure that where they are passing information and rights through to each other on an arm's length, fairly competitive basis, it's done in a way which is a jigsaw that fits together rather than being a bit of a mishmash. It might not, solve the problem, it might not put the infringers off, but it certainly would make or might make enforcement a more streamlined and straightforward process in terms of demonstrating those rights and where they come from.
I think that's it then. Thank you very much, everyone.
Thanks, everyone.